Hello, first, I would like to take the opportunity to say I feel privileged to be able to practice this important duty of participating in a jury as a United States citizen in discussing this case before us. In this case, we discuss case number 3, Public Hospital Corrects Impermissible Disclosure of PHI in response to subpoena. The covered entity is General Hospital. The issue presented is impermissible uses and disclosures of protected health information. The plaintiff is patient Jennifer and the defendant AU Hospital. The defendant, AU Hospital, represented by Monique, maintains that there was no rule or law broken here. She states that because of the subpoena, the hospital facility is obligated to disclose the plaintiff's, Jennifer's, protected health information. She adds it has no obligation to contact the plaintiff to notify her of this disclosure when the request is from law enforcement. AU Hospital explains there was no PHI breach committed because the disclosure is one protected by HIPAA law. She states the subpoena came in with appropriate information such as a written statement with relevant information requests. It was material specific and is limited in scope. On the other hand, the plaintiff, Jennifer, argues that the hospital absolutely violated her protected health information privacy rule by not properly notifying her and allowing her to review the information requested before it was disclosed. She cited legal samples to back up her claim. Because of the improper disclosure of her protected health information without her consent, she is now suing the hospital. The task before the jury here is to listen to both sides without partiality, understand the claim, apply the law appropriate to the case, and present our opinion as to who is at fault. With that in mind, as a juror, here is my opinion based on my understanding of the HIPAA rule, private health information, and the definition of a PHI breach. Health Information Portability and Accountability Act of 1996, HIPAA, was signed into law by President Clinton, and over the past 2 decades, the Federal Department of Health and Human Services has published several sets of rules implementing the administrative simplification provisions within HIPAA, as well as the Health Information Technology for Economic and Clinical High-Tech Act within the American Recovery and Reinvestment Act, or ARA. These rules include a final rule governing the use and disclosure of protected health information, or PHI, by covered entities and their business associates, or privacy rule by Tobino 2016, page 23. The covered entities include health plans, healthcare clearinghouses, and healthcare providers who transmit health information. The purposes of HIPAA are to improve portability and continuity of health insurance coverage in the individual and group markets, combating healthcare fraud and abuse, promote the use of medical savings accounts, and improving access to long-term care services and insurance coverage, and simplifying the administration of health insurance. Under HIPAA's privacy rule, the first rule provides use and disclosure of PHI without prior consent to covered entities and business associates to conduct their business. For example, a general practitioner's release of PHI for consult purposes and treatment of patients is granted with no written consent or prior authorization for the disclosure. It also grants the permission of releasing medical records to payers for properly handling insurance claims and reimbursement without prior approval from the patient. This also from Tobino 2016, page 29. The covered entities may freely use and disclose PHI without any form of prior permission to carry out their own treatment, payment, and healthcare operations activities, as well as certain public benefit activities. The second rule requires a verbal approval to release PHI, and the third rule requires a written approval for the release of the PHI. Per Grossman and Guillory 2004, HIPAA requires that prior to disclosure of PHI, the requesting party must demonstrate the authority to obtain the information, 2, that the patient has been notified and does not object to the disclosure, And under HIPAA, a subpoena is no longer enough to obtain medical records without specific approval from the patient, that the patient has received notice and the opportunity to object. On the other hand, a subpoena signed by a judge is treated like a court order where prior authorization from the patient is not required. Per Stanger, 2013, the HIPAA privacy rules generally prohibit healthcare providers from disclosing protected health information pursuant to subpoenas and other government demands unless certain conditions are satisfied. In cases of a court order, a warrant, a subpoena signed by a judge or magistrate, and a grand jury subpoena, provided all other requirements are met, does not need an authorization from the patient prior to disclosure. A subpoena signed by a court clerk, lawyer, prosecutor, or other, the provider cannot disclose the information unless patient approves either orally or by written approval. In other words, without a court order subpoena, the hospital is required to notify the patient. PHI breach, according to Eisen, Gulick, Wild, 2012, is the acquisition, access, use, or disclosure of unsecured PHI in a manner not permitted by HIPAA, which poses a significant risk of financial, reputational, or other harm to the affected individual. My opinion, based on the information presented above, is that the hospital, having the subpoena but not accompanied by a court order, was in violation of the HIPAA Privacy Act due to its failure in notifying the plaintiff. I find the defendant, AU Hospital, in violation of the rule and should be investigated further to make it compliant to HIPAA Privacy Act to continue providing service to patients. Thank you.